Welcome, my name is Laura McGee, and I'm a divorce mediator and a co-parenting specialist, and you are here at leavestrong.com. Today we're going to talk about the flow of the legal process and how you insert yourself if you're mediating, at least with me here at Leavestrong. So let's set it up. The first thing that's going to happen is there's going to be a filing. So we're going to file. We call these the pleadings, and these are going to be filed in the court closest to where one of you lives. So if you live anywhere in California, we can do that filing for you. It's almost all electronic these days. This is a public record, and everybody's going to know if they search that you are now divorcing. Next, there has to be service. So whoever wants to initiate the divorce will become petitioner, and the other person will now be called respondent. If you're mediating with me, what I'm going to do is simply hand the documents to the other person. It's not going to be like TV. Nobody's throwing documents at you. It's going to be all completely private. What does this mean? When you're served, this triggers a timeline possibility, not a guarantee. From the time of service, as soon as you can be divorced in California, even if you're Angelina Jolie, 6 months and 1 day from service. So oftentimes we're looking at the tax year. If you wanted to be divorced in this tax year, you'd have to be served before June 30th. Sometimes you want to slow it down because you want the advantage of 1 more year married filing joint. Sometimes you're trying to keep health insurance if there's only one person that has an employer-sponsored one. So before I serve, we often discuss what's going to be the best timing for the two of you as a couple. Okay? What's next? When you're served, it says you have 30 days to file a response. The purpose of the response is to set up the argument between the two of you. If you're mediating, you're not arguing. You're here because you want what's called an uncontested divorce with an agreement. We skip this step. Not all mediators do it this way, just so you know, but this is an extra expense, another filing fee, and why pay another filing fee if you're not having an argument? So we just skip it. When you've done this step here together, you're both under what are called automatic restraining orders. ATROs is the acronym. Well, what does this mean? Nobody comes over to your house and handcuffs you. It means that you can no longer cancel insurance policies. You can't clean out the bank accounts. You can't run off to another state with the children. You can't do anything unless you have an agreement. Well, one of the nice things we're mediating is oftentimes there's things that need to be decided right now. And we can negotiate those. If needed, we can even stipulate with an order in the court, and we can ensure that you are not basically held hostage by the fact that you've started a divorce. Okay? These things can be worked out. What's the next step? Sometimes people think they can skip this next step. You absolutely cannot skip it. You have 60 days to exchange your financial disclosures. So there's forms for this, of course, and these are called preliminary declarations of disclosure. There are 3 required forms. You cannot skip them. Okay, this is the minimum you can do, not the maximum. And they're out there in the metaverse, but they're also on my website. Just go to step 2. They're all right there for you. FL means family law. The first form, kind of like the command form, FL 140. It is a checklist of all the other forms that you have to include. And it's going to ask you for 2 years of taxes. If you're mediating with me, what I'm going to do is I'm going to create a confidential shared Google Drive. You're going to put everything into a Google Drive so we can all see everything in real time. And then when the mediation's over, you're going to clean out the drive and you've got possession of your financial information. I do not, because I don't need to keep it. So this is the form that starts with the taxes. It also says you're going to attach your income and expense statement. That's what this form is. This wants to know your last 12 months of income. This one wants to know the last 2 years. So this is, and it wants 2 months, not two forms, but 2 months of your pay stubs if you happen to be employed in that manner. Okay? So this is an income and expense form. The income will be based on, if you're self-employed, you're going to have a Schedule C, or you're going to have your current profit and loss statement. If you're a W-2 employee, you're going to have pay stubs. We're going to discuss, don't do this step before we've had our first session, we're going to discuss what needs to be done in your particular circumstances. And guess what? It's a government form. So the expense part of the form at page 3 is very minimalistic. Apparently you don't have pets, you don't get your hair done, nothing like that. So on my website, there's a budget worksheet already in Excel, and it's very helpful to go and look at your actual expenses. Okay, and that's going to be used, we're going to be talking about how that's going to be used in a minute. So we're going to do the next form. This form, FL 142, this form is going to be your assets and your debts. What do you have? What do you owe? What belongs to the community and what belongs to you separately? Okay, so here's the presumption we start with in California. The presumption is everything that's been happening to you during the marriage has been happening to both of you equally. That's our starting point. Okay? But you might have started the marriage with an asset, or maybe a big fat student loan, one of those big debts. And after, so this is date of marriage, that's the beginning, you became a community, and this is the date of separation. Okay? Date of separation, you stop being a community, and there might be things happening after this date that we have to figure out. The sooner you get into a mediated divorce at the time of separation, the less figuring out we have to do here, where this can be a little complex sometimes. There's exceptions to this rule. And so when you're filling this form out, it has a section called SEP Prop. What does that mean? What is my separate property? You're making a claim that this was yours before you were married, or since you separated. Or perhaps you had an inheritance and you kept it separate, you didn't wash it all into the community. Perhaps you have gifts that you gave each other. Those will still be yours. And you might have taken money out of the community for a non-community purpose. Those people aren't always mediating, but you can. And that maybe community needs to be restored. Or maybe you won the lottery after the date of separation, and now you have some new assets or debts. We are going to work on not only filling these forms out, but collecting the data. This is just a checklist. The documents you're going to put in your Google Drive support your checklist. These are not made up numbers, is what I'm saying. And sometimes we need to use experts to help evaluate what's in here. And part of the work of any mediator, and certainly the way I'm going to operate, is getting you to the experts you need to value what's here. Because maybe we just can't do it on the back of a napkin together. What are we going to do with all this data? That's where the mediator's job is incredibly important, because not only the collection process, the exchange process, but helping you to negotiate, what do you want to do with all of this? How's it all going to work out? So when it comes to child support, I'm going to work straight from here. Basically, it's not, child support is calculated on a statewide guideline. It's not based on how much you think or feel you should pay. It's based on timeshare and how much you each earned. Gross income. Goes into a statewide calculator, the same one the judges use, called Dissomaster. You'll come across that saying, but it's not available to the public. So what I'm going to do is put it in the program. It's going to come up with a number. That's monthly child support. And then there's child support add-ons. And what are add-ons? So there's going to usually be a 50-50 sharing of uninsured expenses related to medical, dental, vision, hospitalization, co-pays, deductibles. That's usually 50-50 once support's been established. And second one, childcare so parents can work. Not for babysitting, so childcare so that you can work or go to school, or basically to advance your or rehabilitate your career. Those are mandatory. And then there's a whole bucket if you're mediating. You get to think much bigger than a judge, more like parents, which I definitely ascribe to, because so many things the judge doesn't either have the time or capacity to deal with that you want to deal with as parents. This might be summer camp. This might be, driving. These are all going to be optional. Do you want to continue to contribute to your children's education fund? What about insurance? Because if you lost the other parent, it could be very costly to raise your children on your own. One of the things I do as a co-parenting specialist is help you to think through what are your options. And what I do is I'm going to give you a parent plan template. It's about 20 pages long. And you can kind of decide off this menu what's going to work for the two of you, and then even reorganize it so it's the absolute best fit for you two as parents, okay? So that's going to be quite a detailed piece of our work here in the mediation process if you have children. Spousal support is a two-step process. The temporary support, that's the first one. Temporary spousal support comes off the same calculator as the child support, whether or not you have children. It's the same calculator. Second step, the courts call it permanent spousal support. I think it's quite a misnomer, so I like to call it long-term support, more accurate. So let's just call it long-term support, long-term spousal support. And that's where we're starting to look at the taxes again. Like, why did I give you my taxes? What do they mean? This is establishing what was the marital standard of living before you separated. And at times, if you're self-employed, we go back more like 4 years if you have highly irregular income. Don't do this step 2 until we've worked together on all of this step, because quite often we're deciding in those initial meetings, what do we really need to collect in your case, okay? That way you're not doing the work and having to go back and do some of it over again. So this is off the calculator. This is negotiated. This is off the calculator. This is negotiated. Make sense? And occasionally in mediated environment, we even have a zero child support, which judges almost never have. And it's something that we can discuss might be a possibility if your incomes are reasonably similar. And also, what if you're nesting? Like, there's so many other things you get to do when you're mediating that judges aren't going to be able to help you with. What are we doing with all this data? We are working towards a final agreement called a marital settlement agreement. It's a contract between the two of you. It establishes what you're doing with all of your assets and debts, who gets what, when, and how. What's our parent plan in a very detailed way? Who owes what support when, like what's your frequency? How long is spousal support going to last? What's that frequency? What are the terms around that? Because that might have a lot too. And once it's in here, I drop it off with the judge, and I ask them to turn your agreement into a judgment of the court, and that's uncontested divorce with an agreement. The only thing that can open up your marital settlement agreement on the asset side is a failure to disclose or inaccurate disclosure. Your insurance policy that this won't be open is you fully and properly and completely disclosed. Absolutely critical. This, child support, spousal support, parenting time subject to modification, because life in this regard can have some fluctuations and changes over time, and we just work together in the future and see what needs to be modified if that's the case. So here we are. It's this is what your uncontested divorce with a mediated agreement is going to look like if you're working with me here at Lead Strong Divorce Services. I have a flat fee approach, and if you want to learn more, go ahead and book a complimentary discovery session directly from my website. Look forward to meeting with you.